All right, icebreaker. At age 17, when you were graduating high school, did you think you'd be sitting on the California Supreme Court?
Well, first of all, let me say thank you so much to all of you for having me this afternoon. This is such a nice event. And you know, Jay, if I had known that you were a professional yoga instructor, I would hire you to lead my staff in meditation every morning. I'll be more happy and productive as we navigate our difficult cases. You know, the short answer to your question is that I'm sure at age 17 I wasn't thinking about anything remotely close to being a judge. I grew up in Sacramento. That's where I spent most of my childhood. I had two parents who were family practice physicians. They had immigrated to this country from Taiwan in the late 1960s. And, you know, they had a very typical immigrant story. They came with their educations, but not a whole lot more than that. And, you know, they worked hard and they learned the culture and the language, and they raised my older brother, and me. Lucky for me, my older brother became a doctor. So by the time I was sort of finding my way, I felt like he had kind of taken care of that. And so I could veer off and do all kinds of other crazy things. But the truth is that I ended up, after I graduated high school, I went to college thinking I was going to be a doctor as well. So I was a pre-med student in college, and I indeed graduated with a degree in biology of all things, and had done the whole 9 yards. I had taken the medical school entrance exam, the MCAT. I had applied. I had gotten into some very, very good medical schools, and indeed I was deferred to go to medical school. And lucky for me, I ended up getting a scholarship to go overseas. But and then after that, I really veered off. You know, what I take from that experience is that so much of what we do in life is just out of familiarity or habit. You do the things that are most immediately visible to you, and I think that's just human nature. But it underscores, I think, the desperate need, I think, for every one of us to kind of look beyond our familiar experience and to take risks sometimes. Not that becoming a lawyer was very risky, but it was unfamiliar, and so that's how, you know, that's how people feel, I think, especially from many communities that may not have had the luxuries of education and of professional training in their families. And it's incumbent, I think, on each of us to kind of be a mentor and try to reach out, because I think those are really the things that make a difference in people's lives. I know it certainly made a difference for me.
Did your parents think you a traitor when you didn't go to medical school?
They were very confused, yeah. They were very confused. You know, but again, you know, the confusion was not sort of like, how could you think of doing anything else? It was more like, well, what are you going to do, you know, if you don't do this? Because, you know, it was sort of what they knew best. And so they didn't have the broad range of vision about, you know, what else was possible, especially in a country that they didn't grow up in a culture they didn't grow up in. And so I suspect that's true of many immigrant experiences, which is that you know, there's a little bit of inherent conservatism, you know, to that perspective, because you're not quite sure. So again, I think that just underscores how valuable it is when, and for me, it came in the form of I had a very lucky experience. You know, when I was in graduate school, before I went to law school, I happened to have a chance to work one summer in a law firm for a man who was at that time a partner in a big Washington, D.C. law firm. I was very interested in issues of K through 12 education policy. And he had a practice that was on education law. And were it not for that, I wouldn't have become very familiar with that area and that the legal practice. And it turns out that this was very pivotal for me in a number of ways. One, it convinced me that I wanted to go to law school. Secondly, the person for whom I clerked, for whom I was a sort of summer intern, essentially, was David Tatel, who eventually became a D.C. Circuit judge, and then I clerked for him after law school. And then, not only that, I made my academic career at Old Hall studying education law. So, very happenstance kind of things, but very significant and long-term impacts.
So I understand you graduated from Stanford, then you did postgraduate work at Oxford as a Rhodes Scholar. What was it like being in England? Did you like that?
What was it like being in England? Well, so the most important thing that happened in England was I learned to cook. Because food was not very good in England. Maybe it's improved since I was there. And the weather was very gloomy. So, and as a graduate student, you have a lot of time on your hands, and you don't have much money. So the combination of factors suggests that you learn to cook, and that actually proved to be very important. But in addition to that, I studied philosophy when I was at Oxford, which was probably the best thing that I could have done with myself. Primarily because, for me, studying philosophy was kind of like a bridge intellectually from science to the law. Those of you who have studied philosophy know it's sort of like, the grand theory of everything. And so that's a very rigorous training. And honestly, it was the first time that I felt like I was really being intellectually challenged to really think for myself, to really write for yourself, to think for yourself, to read books for yourself, to do the things that I think, frankly, most lawyers have to habituate themselves to. I mean, our profession is a very intellectual profession. You spend a lot of time, thinking about stuff. You have to. Gaining that confidence, I think, is something that's very important because, unfortunately, I think too much of what we do education-wise in our country is, focus too much on rote memorization, regurgitation, and those kinds of things. And so really being challenged intellectually is something that I got out of my graduate school experience.
I don't want to take too big of a left turn here, so a short answer, but having studied philosophy too, who's your favorite philosopher?
There's too many to choose from. The most important things I think I read in philosophy are frankly things that come up all the time in court. Think about the notion. Every single person here has thought about it because it's in the law so often. Think about the notion of, for example, causation. There are huge books that have been written about the concept of causation because it's a very slippery concept, as most people who've ever been in a dispute realize, right? And this comes up lots and lots of times in, I suspect, your practice, but also certainly in our court. And I'm amazed, actually, at the degree to which some very deep first philosophical principles are still unsettled in the law with respect to such basic notions like causation. That the training that you get from reading, the long line of philosophers, the epistemologists, the metaphysical philosophers, all have actually kind of a startlingly direct bearing on these kinds of important legal issues.
So what led you to law school?
Well, like I said, I had a little bit of exposure, some good mentors, and indeed, I think in the end, I realized that my real passions. I think I was reasonably good at science, I ended up studying in college and whatnot, but I didn't really have a passion for it. And so, another lesson from all of that was that, people say in kind of a very trite way, you have to follow your passions. That's very hard to do, actually, in life. Because, and it's not acknowledged enough. There are lots of other competing pressures on a person, besides your passions. Have to make a living, you may have family obligations, your passions may not be very practical, or you may not know how to realize them. And so, getting to the point where I felt like, okay, I had a particular set of interests in civil rights, education, issues of equality, opportunity. That's very nebulous. How to go about acting on that was something that I think ultimately I came to conclude law school would enable me to do. But it was a gradual path of realization. It wasn't something that happened overnight.
So you went to Yale, correct?
I did.
And then you had some clerkships. You've mentioned one so far, but you also clerked for a U.S. Supreme Court Justice. Who was that?
I clerked for Ruth Bader Ginsburg.
Tell us a little bit about that experience. What's really memorable about it, striking to you?
Well, I had a kind of unusual experience because I clerked in the term of Bush versus Gore. So that was kind of the overshadowing event for the kind of year that I was there. So a few things I'll say about that. I'll say nothing about Bush versus Gore. About the experience, first of all, Justice Ginsburg is a remarkable person. I'm sure most of you know some broad outlines about her general biography, but she's just an iconic person in American law and American legal history, both because of her, she's had 3 careers actually in the law. First, as a law professor, where she was an expert in civil procedure. Secondly, as a litigator, where she brought some of the most important women's rights cases that are on the law books today. And then thirdly, as a judge, first on the D.C. Circuit and then on the U.S. Supreme Court. And, every day you kind of have to stand in awe of this vast experience and wisdom. She was a meticulous, and still is, a meticulous editor. We used to kind of self-flagellate a little bit because we would turn in, to her, these are just internal memos we would write to her about the cases that are in front of the court, our analysis, our recommendations, whatever. And occasionally we'd get them back, and in incredibly faint pencil markings, which was her wont. She did not use a red pen or something. Incredibly faint pencil markings. She would identify the misplaced commas, the missing apostrophe, the extra space where there shouldn't have been one, and that was her way. That was her way of reading, which suggested that this was a person who read things extremely carefully. Even stuff that these are not documents that are meant to be drafts of opinions or anything like that. These are just our internal stuff that we're giving her our points of view on, but she read everything very, very carefully. And that's instructive for a young lawyer learning good habits. In terms of the court itself, the U.S. Supreme Court is a very, very unique court because not only is it a court of last resort, but it's a court of discretionary review, and as is the court I currently sit on. And so I learned some things about how that kind of court really functions. One of the important things that it does is it picks its cases, and you have to pick carefully because you don't want to waste the court. You don't want either to waste the court's time on things that it need not decide, nor do you want to plunge the court into issues where it may do more harm than good. So, as a court of last resort, obviously it's a tremendous opportunity to have the chance to shape the law. But it's also a tremendous liability in certain ways because there's always the chance that you could get it wrong. And one always has to have that bit of humility about it, that you just could be wrong. And so you always have to think about that kind of margin of error and whether the court's intervention is warranted at a particular point in time. So that was kind of interesting to figure that part out. And then, of course, the cases are uniformly interesting, even the ones you never hear anything about. And so all in all, I mean, no one has a bad experience clerking at the U.S. Supreme Court, and I would say that mine was very, very good and in fact, unique in certain ways because of the big case that happened in our term.
The court has been very divided for a number of years. How do these people get along personally? Or did you ever see that?
It's a great question. I mean, so I have a few thoughts on that. First of all, I think, as is well known because it's been reported many times, some of them are very close personal friends. So Justice Ginsburg and Justice Scalia are good friends, despite their quite contrasting views on many important legal issues. And that's just a personal thing that they have, forged out of many things. One, I think common background as former academics. They served together on the D.C. Circuit for some period of time. And I think they have a kind of genuine admiration for each other, though they don't agree with each other. They have an admiration for each other because each of them has, I think, a fairly, at this point, I mean, they're both long-serving judges, they have a fairly mature and well-defined vision of the law. And, Justice Scalia has his vision, but he respects, I think, the intellectual process by which other people come to other visions. And so he likes that engagement. I really can't comment, I mean, I really just don't know all the inner workings of everybody else and their manifold relationships. I would say that, now that I sit on a court, that, we have a 7-member court, we have lots of different viewpoints on our court. How do we all get along? How does it happen that people don't just kind of, come to be intolerant of one another? Well, I liken it it is a little bit like a family, right? You don't choose your family, right? Just like I don't choose my colleagues on the court. Other people choose them. And you're put in that situation. I have the benefit of actually liking these people. I think they're all extremely upstanding people with tremendous integrity. And there is a tremendous collegiality that we have, partly born out of personality, but also partly born out of an institutional feeling of institutional duty, to try to get to as much agreement as possible on as many cases as possible. So I think the ethos of our court, if I could describe it, is largely one of trying to find consensus rather than each of us 7 trying to develop his or her own purist version of our own views, right? I mean, you could make a career out of writing your separate opinion on every single case. That won't make you a very influential person on the court. You will have lots of your opinions in print, but that has perhaps very little effect on the law. So I think we are slightly more pragmatic than that. And I think that really helps in terms of your question, how do people get along? Well, they get along because they want to get along. It's a kind of attitude or a disposition.
Okay, now we want to get a couple of tips here. So drawing on your experience either as a clerk at the U.S. Supreme Court, if you had a chance to hear oral argument, or what you've been through so far in California, can you give us some examples of really good attorneys and really good argument and why it worked?
Well, so in terms of argument itself, people always ask, does oral argument make any difference? Of course it makes a difference. It shouldn't be assumed. I mean, so let me preface this by saying, cases get to argument in our court only after a tentative majority has formed around some point of view around the case. But I will tell you, in my short experience on the court thus far, the tentative view is often exactly as it is, tentative. Some cases are more clear-cut, and the views are more hardened, but many other cases, they are soft. And I don't think any attorney should assume that once, by the time they've gotten into the courtroom, that something has already been decided. That is a mistake, and it's a disservice, I think, to the client to think that, right? So I think the attorneys who are very effective in our court are ones who come obviously prepared and know the record and know the arguments well, but also are very much trying to listen to what is being asked of them, right? Because it's really the attorney's opportunity to seize on what appears to be the real focal point of what is really bothering the court. I really say that because by the time attorneys appear before us, we have thought a lot about the case. So we're not asking questions in a kind of academic way. We're asking questions about things that are really bothering us. After having thought it through very carefully, what's left that we really are still confused by? And that's really what we're asking. And so an attorney should try to, I think, approach the argument with that perspective. Instead of saying, instead of trying to brush aside questions and say, well, Justice so-and-so, that's really not the most important question in this case. This is the issue. Well, that's a sure way to get a thumbs down performance, because I think that's, it may not appear important to you, but to that particular person, that may be the pivotal issue. And I think many attorneys are surprised that, by the time the opinions are written, the cases sometimes look a little different than the way they were argued. There's no way you can completely predict that, but that just goes to say that when people are asking questions in argument, it pays really, I think, to try to really listen carefully as to what they're asking.
Does it make any sense to come in with a set of prepared remarks, or do you just have to be able to dance on your feet and...
Prepared remarks rarely get used because you're interrupted by the court so quickly.
Right, so I understand you spent some time in academia, Gold Hall. How many years?
I was a law professor for 8 years.
Enjoyed it?
I loved it. I loved being a teacher. I loved being a scholar. It was an incredibly, I would say, incredibly privileged opportunity. I mean, you get paid to write and think about the law, and then inculcate that to other people. I mean, that's a marvelous job. I think most law professors will tell you they would do it for free if they didn't have to grade papers. So I love it, and the teaching part especially. I mean, I just love the interaction with the students and learn so much. I mean, I used to teach the Introduction to Constitutional Law course, which I think is my most favorite class to teach. It's just chock full of history and richness in terms of the very basic questions of the society that are still being debated today. And every generation, every class of students comes to it with slightly different perspectives and concerns, and so it never gets old, at least not to me. So I really enjoyed it, and luckily I've been able to keep my hand on a little bit of the teaching. I've taught it. I taught at Stanford last fall. I'll be teaching at Bolt this. I'm equal opportunity. I don't want to get myself into trouble with either school. So I try to stay current on things that I'm interested in, while also having a chance to work with students.
So before being elevated by Governor Brown to our court in July of 2011, you were under consideration for a position on the circuit court, and there was some controversy about that. You became a focal point for some political discussions.
Yes.
What was that like personally?
Personally, it was unpleasant. I mean, anybody who's ever been in the public eye knows that it's an inherently uncomfortable position to be in. It is not true that when people say there's no such thing as bad publicity. Yes, there is such a thing. So, you know, in broad strokes, the federal confirmation process, I think most observers would agree, is a complete mess. It has become a highly politicized endeavor, and it's not the fault of any one party or the other. It's a long history that goes back many decades, and believe me, all the people involved in it have very long memories. So, you know, the knot is wound very tightly, and it's not exactly clear how it's going to be unwound. For someone like me, who is kind of put into that maelstrom, the one thing you realize very quickly, I mean, it's very uncomfortable to be politically attacked and to be personally attacked and to, you know, be attributed things that you didn't, you know, say or don't believe or whatever. But what you realize very quickly, I think, is, and you have to realize this, is that it really is not about you. Some of it is about you, but much of it is about something else, which is the longer history of this whole process and grievances that were never addressed, and hurt feelings that, you know, go back many nominations. And so depersonalizing it a little bit is one way to kind of get through the unpleasant aspects of it. And you also, I mean, for me also, I've recounted a little bit about my personal history about how I came to the law. You know, not only did I have no idea I would even study law, I certainly had no idea that I would become a judge. I mean, when I was a law professor, I was happy as a clam being a law professor. If you had asked me when I was a law professor, are you going to become a judge, I would have had the same reaction as, you know, when I was studying for medical school, whether you thought I would study law. The answer is, you know, who knows? I had no idea. You know, it was not something that I planned my life to do. So that induces, I think, a little bit of, at least for me, hopefully some perspective or humility about these kinds of ambitions. It's a matter of grace, really, when it works out. It's not a matter of expectation or entitlement. And I knew that I wasn't going to organize my life around this possibility. To me, that's kind of a fool's errand, because as I know very well now, there are so many things you cannot control about that process. Right? So after the Senate decided not to vote, to give me a vote, I withdrew my nomination because I wasn't going to continue to put my life essentially on hold for the remote possibility of some kind of political change or breakthrough. And indeed, it would have been a disservice to the court, too, because these courts need people to serve on them, the Ninth Circuit in particular, and to have a nomination languishing out there when someone else could be nominated and fill it, I thought was not responsible. So the phone call from the governor's office was a complete surprise to me because, of course, I was disappointed and I was very dejected, actually, after the whole Ninth Circuit experience. I had no idea that this next thing was about to happen. But as a matter of fact, what happened was right after the Senate closure vote, the governor's office called me and said, you know, would you like to have a conversation about the California Supreme Court? I said, sure. And I remember very clearly, you know, that very day of the phone call, I met Governor Brown in his, he keeps a loft office in downtown Oakland where he used to be mayor. And we had a 2-hour conversation about extremely wide-ranging subject matter. It was very unlike the federal confirmation process. I still remember, you know, his first question to me, when I didn't, and I don't know him. I mean, I've never met him. I don't have any political connection to him or anything like that. I mean, this was like totally out of the blue. His very first question to me was, so, what do you think is the basis of law? That's refreshing. You know, what do you think? You know, not what do you think of Roe versus Wade? Or what do you think is the basis of law? And so then we had a 2-hour conversation about, you know, theories of the law, natural law, social contract, you know, all kinds of philosophers from Locke to Montesquieu. I mean, he is incredibly intellectually adept and agile. I mean, he's read all these people. He's thought very much about them. And it was just, it was unbelievable, actually. But then I left the interview and I said, I'm not getting that job. We just had this conversation, which had nothing to do with anything. And so really, I put it out of my mind. That was in May, or I think it was in May of 2011. And for months, I didn't hear anything. I just thought, you know, I was ready to move on, actually, with my life. I was thinking about getting back on my academic career and doing other things. And he was fighting a big budget battle, as happens every summer in Sacramento. And it wasn't really until late July that I got another call from his office. And you know, his aide said, the governor wants to see you again. And I thought, oh my goodness, you know, what is this about? And so I went, did the same thing, met in the same place, had another 2-hour conversation about the theories of the law. And then a few days later, he said he was ready to appoint me. Wow. So it was just an amazing journey from, you know, being nominated to the Ninth Circuit, which was a major high, and then being denied that opportunity, which was a major low, and then being rescued essentially by this opportunity, which, I mean, it was just an emotional roller coaster.
Well, congratulations. We're very happy to have you. Let's turn to something a little more mundane. So, what do you do on your first day? Do they assign you a robe?
Well, so actually, that's a very good question. And it was a very pertinent question, because I was confirmed on August 31st of 2011, and so my very first day of work was the very next day, September 1, and there was some imperative in trying to confirm me, because the Proposition 8 case, the same-sex marriage case, which had been bubbling around federal court, had been returned to the California Supreme Court for a certified question on the issue of standing. I think some of you remember this. The question was whether these initiative proponents, the Prop 8 proponents, could in effect take an appeal of the federal district court's decision against them when the government, who normally defends the laws, decided not to do that. Right? So the government doesn't want to defend the law. Can the initiative proponents stand in the government's shoes? Our court said, as a matter of state law, yes, they can. Anyway, that case was argued, I believe, September 6th, the day right after Labor Day. And so essentially, I had, you know, from September 1 to September 6th, to not only find where the bathroom was, but to, you know, to get ready for the case and get on the bench. And the matter of the robe was one of some question, because I didn't own a robe. I mean, why would I have a robe, you know? It turns, and so I thought, well, isn't this like a kind of government-provided thing, you know? And I show up, and it turns out it's not. The judges who are here already know this, but this is something you have to go get yourself. Oh my goodness, you know, where do you get it? And not only that, it turns out that there's a statute that governs the robe. It was shown to me. There's a statute that governs the length of the robe, or some. I mean, there's a statute on everything in California, which I've come to realize. And so it had to meet, you know, certain kinds of requirements. So anyway, I borrowed a robe, and then I eventually got my own robe. But I was on the bench, you know, 5 days after being appointed, and so that was a little bit exhilarating. And you know, that day was, you know, of course, cameras and protesters, and all the whole full dress, you know, it was like the whole thing. And Ted Olson was arguing the case, Chuck Cooper, I mean, these very famous lawyers. And so it was really quite a thrill, actually. I mean, if you think about, you know, what you think a first week on the job might look like, I mean, that was really quite heady stuff. And since then, I think it has been a very easy institution to kind of get yourself into, because the California Supreme Court is, as you might expect, it's an incredibly proceduralized place, as courts are. And so me walking in, it's not like I'm going to change a lot of things. The biggest thing I changed, which is a change from from the convention at the court, is I decided to hire law clerks on an annual basis. So the California Supreme Court, all my colleagues use career clerks, meaning they're permanent staff. I preferred to have a mix. So we have 5 positions for each chambers, and so I kept two positions as permanent, and I have 3 now that follow more the federal model of young recent graduates, recent attorneys spending a year with me, going back out into the world. I think this is really important, actually, both for my selfish interest of having fresh perspectives, as well as the relationship both with these incredibly bright young attorneys, as well as their law schools. But also, I think it's a tremendous opportunity for the bench and the bar, insofar as these people will go on to do amazing things. They will become the attorneys who bring us the cases. They will become the scholars who write about what we do and hopefully improve upon it. And they just become a permanent asset, to the court as the court's alumni. And so to me, that's actually, it's just a drop in the bucket, but it's actually a very, very important benefit.
Okay, I understand our time is running short here, so I'm going to ask us a few more kind of short, focused questions, and then open it up to questions from the audience. How do the justices decide who will author an opinion?
So the Chief Justice has the assigning power. Once a case is granted in our court, it is immediately assigned. And I actually don't know how she makes those decisions. You'll have to ask her.
How long are the odds of a petition for review actually being granted?
We have about 5,000 petitions a year, and about 80 are granted, 80. So less than 2%. I'll just tell you very quickly, the principal criterion for getting a case granted is not whether or not the case was rightly decided by the Court of Appeal. That is, I think, a minimal consideration. We are not, in that sense, a court of error correction. We are a court of finality, which is to say that we are trying to settle questions of law that are bubbling around the courts of California, where there is disagreement and where there ought to be uniformity. So the primary criterion is to demonstrate that there is some disuniformity in the law that really warrants the court of last resort's intervention. And mere error in the Court of Appeal is not itself a reason to invoke a higher court to correct it.
So my last question will be, what are some of the big issues coming before the court this year?
Well, we have so many. One of the cases that has gotten a lot of press concerns the question of whether an undocumented immigrant who has passed the bar exam, has a law degree, and otherwise qualifies for admission to the bar can be given a bar license. There is another case that concerns medical marijuana. The question is, as some of you know, the state of California has laws, state laws, that authorize certain medicinal uses of marijuana. It's a very elaborate scheme. And it immunizes that conduct from state criminal sanctions. The question is whether cities, localities, can enact local ordinances that prohibit medical marijuana dispensaries within those city limits. I have an interesting case in front of well, it's in front of all of our courts, all of our chambers right now, that concerns marijuana, but it's not medical marijuana. A guy goes into a Federal Express office store, and he leaves a box there for shipment. The clerk takes it, he leaves, and the clerk smells it, and it smells like marijuana. So the clerk calls the police. Police show up, smell it, yep, smells like marijuana. They take it they take it away and they take it to the police station, and the officer shows it to us. Lieutenant smells it, says, "Yep, marijuana." And then they open it, and what do they find? They find marijuana. They do this all without a search warrant. So some of you, that there is what's called a plain view exception to the warrant requirement. So if you have a bag of marijuana in a clear plastic bag sitting on a table, the police don't need a warrant to go get that bag. So the question is there a plain smell exception? It's not an easy issue. So we have lots of interesting cases. I could go on. I mean, all of them are murders.
Lisa, do we have time for any questions or not?
Sure, maybe one or two real quick ones.
All right, does anyone out there have a question? If not, that'll be easy enough. So I really want to thank you for taking the time to come and talk to us. It's been very informative. I think everyone out here has really enjoyed it. Let's give a big
thank you. Thank you.